Thank you. Good morning, judges, and may it please the court. My name is Adrienne Turner. I'm representing the appellants, Mr. McClellan and Ms. Silver. Our position this morning is that the trial court or the district court erred, of course, in granting summary judgment and in finding that the government had met its burden of proving by a preponderance of the evidence that the funds that were seized and made subject to forfeiture in this action were proceeds of drug activity. The government's burden in this regard is certainly pursuant to CAFRA, an absolute burden to affirmatively make this showing by a preponderance of the evidence. And here, there's just an absence of evidence that should have been considered in reaching the determination as to whether summary judgment was appropriate. One of the issues that occurs to us first is that the district court, in setting forth what the appellant's argument was, the claimant's argument at that level, is that they argue that the court says that the claimants argue the defendant currency consists entirely of profits from their retail clothing business, which was labeled Style House. Now, while the claimants did make that allegation, the court's summary is a complete understatement of the appellant's position in that regard. The appellants alleged that a $100,000 inheritance that Mr. McClellan received and used as seed money for that clothing business was intermingled with the revenue that was generated from the business, and that the amount of money that was seized from him in cash on the night in question was not just purely profits that came from, just nowhere. and then all of a sudden there was this business.
Counsel, if the only verifiable income from the tax return showed that Silver and her family were living below the poverty level at the time of the seizure, then how could it be that labeled Style House produced profits sufficient to cover the seized assets in this case? We're talking about profits of a substantial amount, close to $70,000. And when you try to match that up against the income tax, it seems a little bit difficult to see that these were legitimate assets. But and that's before you get to the substantial evidence elsewhere that these were tainted assets.
Actually, Your Honor, the fundamental issue that we have with the lower court's analysis there is that it completely and expressly, the court says, I have not considered this $100,000 inheritance that Mr. McClellan provided to the business as seed money at all in this analysis. So what, from the court's order, what seems to be profits from nowhere actually fails to consider and correctly analyze the nuances between operating cost and business revenue versus what.
Can I back you up a second? Do you agree, hypothetically, that if they had made a false exculpatory statement, that would be affirmative evidence, right? So if it turned out they said something that was false, they said this money came from little green men that dropped it from a UFO, right? Something that's obviously false, that would be affirmative evidence of guilt.
I think that the government's burden is to bring forth evidence itself.
But one type of evidence would be a false exculpatory statement.
I think that's negative evidence.
What do you mean negative?
I think it shows, or it's trying to meet the burden of showing a preponderance of evidence by showing a lack of a legitimate explanation for where the funds might have come from. And that's not what we have here. And I'm not, and the allegations as far as the inheritance money, Your Honor, are no one says he didn't get it. I mean, it's completely traceable. It works as far as the temporal.
The statute says that circumstantial, or the statute allows, it's a civil proceeding, and it allows the admission of circumstantial evidence. And aside from the fact that it seems a bit of a stretch of the imagination to think that the Style House produced these sorts of profits in light of the income tax returns, how do you deal with a substantial amount of circumstantial evidence that these were not legitimate assets? I mean, legitimate assets transported in this kind of way.
Well, Your Honor, first of all, there is no substantial evidence regarding the transportation of the cash. In this case, the court cites many cases that deal with the manner in which cash money is transported, and none of them match the facts of this case. In every case that the court includes in its order, there's some special packaging that is used to try to conceal the cash currency from detection. That's not present here. Every case that
well, why wouldn't the concealment of the currency in a Nike duffel bag in the trunk qualify as evidence of concealment?
Your Honor, I see that I'm out of time, but if I might address your...
Can you answer that on rebuttal, because you have reserved some time for rebuttal?
Thank you, Your Honor.
Mr. Johnson.
Morning, Your Honors. Robert Johnson for Amicus Curiae, the Institute for Justice. I'd like to start just by taking a step back and focusing on the legal standard in this case. Congress and the Civil Asset Forfeiture Reform Act.
Before you get to the legal standard, which I think we've got a little bit of a handle on, can you help me understand this dichotomy? Because you want to say that they're flipping the burden, right? But I think, or I hope you will acknowledge that a false exculpatory statement is affirmative evidence of guilt, right? The Supreme Court's been saying that for more than 100 years. Help me understand how those two play together, right? Because if you had, or not you, but if the claimant here had moved to dismiss at a Rule 12 level, maybe there would not have been an affirmative statement that was there. But now they've given these statements. And if they are proven to be false, and I understand she can test that they're false, but hypothetically, stay with me for a minute, that they are false and they are affirmative evidence of guilt. So not that the burden has been flipped to them, but the falsity of their statements is in fact evidence of their guilt. That's not flipping the burden, right? That's like just giving evidentiary weight to a false exculpatory statement, right?
Well, I think yes and no, Your Honor. I think it's possible to give some weight to that statement. I think the question, though, is whether that statement is then sufficient to say that the government has met its burden.
Totally get you there. But what I'm saying is that move is not flipping the burden. You then still have to apply the burden. But you agree that in doing the analysis, if we had the scenario where they said little green men dropped this money out of a UFO, and the government was able to put forward evidence that there are no UFOs in little green men, then we would say that is evidence of guilt, right? Or here, evidence that the money was from drug trafficking because it's a false exculpatory statement.
Well, I agree that it's evidence that there must be something that they are not telling the government. Whether it's evidence that it's proceeds of drug trafficking, I think is a different question. That's part of the issue. The government has to prove that this money is traceable to drug trafficking. And
well, let's say that I would say, assuming just purely arguendo that there was a flipping of the burden. I wouldn't concede that at all. I don't understand why under however you place the burden, and we can affirm on an alternate on any basis. I don't see how there could be a failure to meet the burden here, given the fact that there are ion scans of the defendant currency that actually showed cocaine. That's only one of the evidentiary marks here, and you seldom get a case that's clear. And I understand that there are problems with civil forfeiture, and I respect where you and the Institute are coming on this issue. And I understand that it can be abused, but here it did seem to me that the accumulation of facts could not be less favorable for you. It just seemed to me that, that when you begin to pile fact after fact after fact, there are a lot of cases it would be favorable to you, but my problem is not with the overarching view that you have of civil forfeiture. I respect that. It's simply with given the facts of this particular case, they seem very inculpatory. They seem hard to overcome.
Well, Your Honor, I think this case is ultimately about the right to trial by jury. And I would say on the question of the ion scans,
no, but if it's a civil case, which this is, you're under the summary judgment standard, and there has to be an issue of triable fact. And I wonder how you get an issue of triable fact when you have ion scans of the cocaine on the defendant currency, and you have this stuff is stuffed in a duffel bag in the trunk, and you have when McClellan is describing his occupation to law enforcement at the time of the seizure. He doesn't mention anything about Stylehood. He has Style House. He says, "Oh, I'm just doing a lot of different stuff." And then you have the currency in bundled increments with rubber bands as opposed to bank bands. And it's just very unusual to have $70,000 in legitimate currency bound by rubber bands. I mean, and stuffed in a duffel bag in a trunk. And then you get all of the prior acts, which I think you had $50,000 in cash seized by the DEA in 2013. At some point, these different facts assume a cumulative weight that's difficult to overcome.
Your Honor, I would just direct the court to United States versus $10,700 from the Third Circuit, which is a pre-CAFRA case, and found based on a similar assortment of facts, including ion scans, that the government had not even met the probable cause standard for civil forfeiture. And again, I think this case is about the right to a trial by jury. And the question here is not whether the government on these facts could forfeit this property after a trial. The question is here, should the judge be allowed to draw factual conclusions based on the evidence result.
But that's too general. You have to deal with the specifics here and why they establish an issue of tribal fact. Every summary judgment case that comes up here on appeal, they say it's a matter, the losing party on summary judgment says, well, this is a matter of right to trial by jury. Well, the right to trial by jury is important, very important in a civil case. But under Celotex, you have to establish an issue of tribal facts. And Chief Justice Rehnquist makes that clear in his Celotex decision.
Yes, Your Honor, but Celotex also holds that the party who does not bear the burden of proof doesn't have to provide any evidence at summary judgment. That's the holding of Celotex. And of course, the government here is the party that bears the burden of proof. And the other thing I would just point Your Honor to in terms of whether there's a tribal fact, at page 43 of the appendix, it shows that Label Style House had gross receipts of $41,000. In 2018, page 48 of the appendix, gross receipts of over $62,000. And I could go on, and all I want to say about that is, if you take a business and it starts with $50, it buys inventory for $50, it sells it for $52. At the end of the day, that business has $52 in cash, and it has $2 to report in profits on its tax return. And I think the evidence supports an inference that that is exactly what is going on here. And I see that I'm out of time, Your Honor. Thank you.
Thank you. Ms. Sherrod, we'd be happy to hear from you.
May it please the court. In this case, the government met its burden to establish that the approximately $70,000 in cash was subject to forfeiture as drug proceeds. And in this case, the district court properly granted summary judgment to the government because the only evidence in this case is the government's evidence that establishes by preponderance of the evidence that it's drug money. The district court took care in this case to look at a number of factors in determining.
Can we talk a little bit about some of the specifics here? So what's the probability if I pull the cash out of my wallet that it's got cocaine residue on it?
Your Honor, unfortunately, I can't answer that, but it seems unlikely unless you're a drug dealer, unless your money's been in.
There's some suggestion. I'm not a drug dealer. That's just true, not a false exculpatory one. But there's some suggestion that's not really right. And there's at least some reports that have suggested that a large proportion of the currency that circulates around has cocaine on it, right? And the problem I've got here is that you may be right. The probability in my pocket that it has residue from a previous transaction when I, paid for a pack of gum at the 7-Eleven yesterday, that might be extremely low. It might be extremely high. But on this record, how can I tell whether the presence of cocaine on the currency means anything at all?
Well, I think you can consider the fact that I believe there were numerous or several positive ion scans.
Well, there were ion scans for cocaine and one for explosives. Do you claim the claimant was in the business of selling cocaine or explosives? I thought it was marijuana.
Your Honor, we do not specifically identify the type of drug. The law allows us to forfeit drug proceeds related to drug trafficking in general. So, of course, based on Derek McClellan's prior criminal history, it would suggest
that's the convictions from 6 years ago and 12 years ago, 6 years before this forfeiture and 12 years before the forfeiture.
That's correct. In 2013, he was convicted of possession with intent to distribute marijuana.
How long do you think is too long to infer based on someone's prior conviction that they are currently involved in selling drugs?
Well, I think that's just one of many factors. We would certainly look at the prior convictions, but for instance,
how do you look at the prior convictions, right? Why under 404B in our case law, why do you get to look at them to suggest that he's a drug dealer? Right? That's exactly what 404B tells us you don't do, right? That's pure propensity evidence. You're saying because he was a drug dealer before and got convicted, he must be a drug dealer now. That's precisely what you can't do. You might be able to do something, but you can't do what you've just said, I don't think.
You're correct, Your Honor, but we can offer it to show knowledge. And in this case, it's particularly instructive.
Knowledge of what? See, that's the problem. You can't just say that, like knowledge of what? Of knowledge of a lot of money?
Of how to move money. So if you go back to the 2013 case, you see that he was transporting the money in the exact same way that this drug money was being transported in 2019. It was in a bag.
That was the forfeiture. That was the forfeited money. The
forfeited money of the approximately $50,000, if you go back and look at that, was bundled, which is, of course, indicative of drug trafficking.
Is that associated with a conviction?
In state court, I believe it was. But of course, he didn't contest that, I think is what he actually told the agents when he was initially encountered by Homeland Security at the time of this seizure. He said, of course, hey, I know about forfeiture.
So under 404B, the one argument you're making is it shows knowledge of how to transport cash. All right. What else under 404B that's not propensity do you think that those convictions actually are allowed to show? I mean, because the district court, maybe, not fully thinking this through, seems to say, well, he has been convicted before and therefore must be a drug dealer now. I mean, it sounds a lot like propensity when you read it. It doesn't sound like he's saying this is about knowledge of transporting cash.
It certainly shows knowledge. It shows motive, why he would be transporting the cash. We do think it would come in.
How would it show motive? Help me understand that. Why would that show motive to transport cash, that he's been previously convicted?
Well, because again, given the circumstances in 2013 and today, we see that he knows how to move drug money. And so that would be his motive, to move the drug money, to move his drug business forward.
Right, but knowing how to transport cash, he would also know how to transport cash if it was wholly legitimate, right? So if he was just engaged in a cash business, it would suggest that he would transport cash in the same way he did before. And why does it show? The part of it it's not showing to me is that he's a drug dealer, unless I say it's propensity. And I get the urge to say it's propensity.
Well, again, we consider that to be one factor in the many factors in this case that show it's drug money. Even setting that aside, going back to how the money was packaged, that it was banded into
how would
bundles.
a person who has this quantity of cash, this large amount of cash, how would they package it safely and in an organized manner, but make sure that the government knows it's not drug money? How would I carry that in my car?
Well, Your Honor, I certainly can't answer that. I guess there's any number of ways. You certainly could stick it in a bag and put it in your car. But you would also be prepared to tell the government if you were stopped.
I guess what I'm troubled by is just, if you have a large amount of cash, whether it's because of a legitimate reason or an illegitimate reason, you probably want to keep it out of sight, right? So in your trunk, and you don't want the bills just floating around in the trunk, right? So you've got to bundle them perhaps, put them in a bag. That all makes sense, whether they're legitimate proceeds, illegitimate proceeds. You might say it's a large amount of cash, so that seems a little fishy because most people don't carry large amounts these days, but fishy, and by a preponderance of the evidence, no one could say this is anything but drug proceeds, are very far apart from each other on the spectrum.
Well, Your Honor, I think what I'm just hearing you say right there is sort of what they call the divide and conquer approach, which I think the courts have explicitly rejected in this series.
Sure, yeah, there are definitely other factors. I'm just thinking when we see cases about drug money, it's wrapped in plastic so that drug dogs don't, detect it. Maybe it's hidden in a secret compartment of the car. And that's not to say that an officer can't testify that when I, see proceeds of drug transactions, it's often bundled exactly the way we have here. But I'm saying, how can we, even considering that with other factors, that it doesn't seem to me that pushes you over the line, that no juror could say, well, this is also how, I'm not convinced that this is drug proceeds, because that's how anyone with a large amount of cash would sensibly carry their money.
Well, again, looking at the totality of the evidence, a legitimate business isn't going to be transporting their cash in this manner, and certainly not in the wee hours of the morning on a Sunday morning in a vehicle driven by somebody who apparently was intoxicated and rolled into a concrete barrier.
Where is the legitimate source of the income? That's one of the questions among many that I have. If you could point out that there was, wait a minute, here's a legitimate source of the income. But when he's describing his occupation to law enforcement officers, he said, I'm just doing a lot of different stuff. And then this whole thing about Style House doesn't match up with what's in the income tax returns. The income tax returns don't show any legitimate source of income that would cover $70,000. It's not just one thing, it's the accumulation of things that go here. And you're absolutely right to say this divide and conquer business is the easiest thing in the world to do. You just take one thing and say, well, this by itself doesn't indicate this and this by itself. But it's not that, it's the accumulation of it all. Where is the legitimate source of the income?
Exactly as Judge Wilkinson noted, one of the many factors here is the lack of legitimate income. That is substantial, but it's also the false statements made by the claimants. You know, they put forward on more than one occasion sworn statements. This money, it consists entirely of profits of this label Style House.
And I don't mean to divide and conquer here. I agree that that's an incorrect approach, but I'm looking for where's the evidence that you have to prove, right? The government has to prove that this is connected to the sale of drugs, not just that this money is illegitimate, not just that this money came from illegal profits or wasn't reported on tax returns, or that, you know, that it came from a bad source. What you have to prove is that it came from drug sales, or it's going to be used for drug purchases, that it's somehow traceable to a federal drug crime. So what's your best evidence of that? And it, you know, you can give me a list. It can be a cumulative list, but I'm looking for the connection to the drugs.
Certainly, Your Honor. And maybe the best place to start is the expert's opinion in this case that the government put forward. He is an experienced former IRS criminal investigator and Homeland Security criminal investigator. He's also an attorney, as an aside. So that's someone who has extensive knowledge of how drug dealers move money, what drug money looks like, and what factors we look at. His expert opinion runs through all of those factors and, you know, reaches the same conclusion basically that the district court did, which is that this has got to be drug money. So, you know, I'd start with that, look at the analysis that he applied, looking at the way the money was bundled, the amount of currency, how it was discovered, the lack of legitimate income, which courts across the country have indicated is indicative and certainly informative in cases like this. Look at the tax returns. And yes, under 404B, we would say, look at his prior drug history. Look at the statements he made at the time of the seizure, not wanting to disclose what he did for a living, which, again, there's no record that he's done anything legitimate for a living because he doesn't file any tax returns and certainly has never disclosed what his actual.
Do you have a case, and you may, I just don't recall, but do you have a case where the government was granted summary judgment on this forfeiture because it was drug proceeds, where there was no evidence that the claimant was currently involved in trafficking drugs, right? Drugs weren't found with the money. This person wasn't otherwise, they didn't search their home and find drugs. This person wasn't there was nothing else to indicate the person is currently involved in drug trafficking.
Well, certainly we would say, I guess this is two sides of the same coin, so let me explain that before I cite a case. One is that it is sort of a misnomer that drugs and money have to be found together in order to be forfeited. You know, if a substantial drug dealer is going to purchase 2 kilos of cocaine, which $70,000 would probably come close to purchasing, they're not going to have the drugs in their hand. They bundle the money in specified increments to make it easy for a quick exchange. And once they've made that exchange, they get the cocaine back. They don't have the money anymore, and vice versa. So we don't.
That's also how like a retail clothing business would work, right?
Possibly, but in this case, if you want to talk about the retail clothing business,
I just was saying that like that's also how you like buy and sell inventory.
Well, except for they usually don't do it in $70,000 in bundled cash. But here, of course, the government served claimants and said, show us your business records, show us where all this merchandise is coming from and what you're paying for. And you know what they produced? Nothing. So again, like the idea that this is labels money is simply a fallacy.
You mentioned that bundled increments. I didn't see anything in the record about what the increments cash here were, just that they were rubber banded.
Certainly,
but let me know if I missed that.
Certainly, Your Honor, that is in the complaint. So if I could turn to the JA.
Sure.
It is in the complaint. I believe we almost always include the breakdown. Yes. So there were 187 $100 bills, 77.
Yeah, thank you. That I'm curious about. You mentioned that they keep them bundled in certain increments to make for a quick exchange. And I had been curious about that, whether, the rubber bands were, each, were they bundled by these are 20s, these are 50s, these are hundreds, or was it bundled as like each bundle is $100 or $150 or whatever the increment was? I didn't see anything in the record about that.
I don't know that they actually looked at each bundle. They looked at the type of the denominations, I should say, and that is something that we look at, or law enforcement looks at when we're looking at drug dealers and the currency that they transport.
So the thing that I keep coming back to is that in most of these cases where civil forfeiture is in question, there has been at least some remotely plausible alternative means that served as the source of legitimate income. In other words, the defendants have been able to point to a legitimate source of the income. And I don't see that happening here. All of the explanations for a legitimate source of the income, they're vague, they're shifting, they don't match up with the tax return. But these cases, and I've seen a number of them, where it seems to me the government runs afoul is when it starts saying these are drug proceeds, where the defendant actually points to a legitimate source of income and says, this is where they come from. I have this business, it's profitable, you can see that it's profitable, or whatever. Now, the defendant doesn't bear the burden of proof, but on the other hand, Celotex makes clear you can't just sit there. And what distinguishes this from the other drug trafficking, from the other civil forfeiture cases that I've seen, is that I don't see that there's a plausible case made out that there is some legitimate source of income. And that's a characteristic of a good defense to a civil forfeiture claim.
Certainly, Your Honor. And I do want to make clear, because if this has not been clear with the government's position, we have no interest in forfeiting clean money. We have an interest in forfeiting dirty money, drug money in particular, specifically which we believe this money to be. And in this case, they did not.
How do you know that this is drug money instead of money from counterfeit goods, which I think was the government's alternative theory below?
Well, Your Honor, again, we do have evidence that Labels, to the extent it was doing a legitimate business, was dealing in counterfeit goods. To local law enforcement, it was known colloquially as the little counterfeit store. Obviously, the state law enforcement division had launched an investigation into Labels. But money frequently is or can be forfeitable under more than one theory. We rarely, want to go into court.
Can you help me understand that just for a minute? We sometimes in the criminal context think about the difference between elements and means. And so I guess what I'm wondering is, if this went to a jury, just hypothetically, would the jury need to agree on what the criminal predicate was, or would it suffice? In other words, that would be their like elements of your claim, or would it suffice to say that it's the proceeds of criminal conduct, and either of those would satisfy the criminal conduct? So those are two different means, meaning you don't require unanimity.
We would ask for unanimity because I do think that they need to make a decision how the money is forfeitable. The tricky part in this case.
Say that one more time. So in other words, the jury instructions would say, you must agree that it is drug proceeds, or you must agree that it is counterfeiting. You can't, some of you think drug proceeds and some of you think counterfeiting.
I apologize, Your Honor. It also could be both. And that's what I was getting ready to explain. If we assume labels is a cash heavy business.
Right. Okay. I know that, but go back to this point. Sorry. Cause I'm not sure you're right about this, and it's against you, which is why I'm trying to make sure I understand, because you could say that these are just two different means of satisfying the element of that is the proceeds of criminal conduct, in which case you would not require unanimity, right? I understand it could be both, right? Both is always true. Even if they're two elements, they can meet both of them, like use and possession, right? But where they're just means, you wouldn't have to have unanimity. So some of your jurors could think drugs, some of your jurors could think counterfeiting, but your view is there've got to be agreement on one or the other, or both.
Well, or within that. So for instance, some of the jurors could say $40,000 we think is drug proceeds and we think $29,000 is
But they've got to agree on what the predicate is.
That the government has met its burden, that it's forfeitable under one of
a particular theory.
Under those theories,
Would a judge even instruct on counterfeiting? I mean, what evidence is there that some of this was counterfeit funds? I mean, I don't know that a government would, seems to me you can meet your burden on drugs if it were counterfeit funds. I'm not sure you can meet your burden, and that would have to be some evidence of counterfeit funds in order to get an instruction on the point. And I'm just not sure there would be. I think it's a drug case, pure and simple. There's no evidence of counterfeiting.
Well, Your Honor, we certainly would agree that the drug theory is much stronger. I see my time is out.
Ms. Turner, you have some time for rebuttal.
Yes, thank you, Your Honor. One of the questions raised by the court involved some differing statements regarding the legitimacy of the income. And we wanted to point out that in his first statement to police, Mr. McClellan disclosed the existence of Label's Style House. It was a real business. He told the police that's where this money it's from. It's an operating business. It has.
Where is the evidence of it that the income or that the profits from Style House were able to reach $70,000?
Well, Your Honor, I think that one of the things that is absent from the district court's order, but that bears attention, is that nobody's disagreeing that Mr. McClellan had $100,000 available to him, perfectly traceable, perfectly legal. There is no question about that. We know where it came from. We know that he inherited it. Not only that, but he also inherited a house that was paid for that cut his expenses dramatically. And yet, rather than sending the question to the jury regarding whether his ability to provide that money to the business would allow for those figures and for him to have that amount of cash, the issue was determined just.
Well, I suppose that if this is a triable issue, then almost anything is because of, but there is an old thing that things can't be submitted to the jury just on the basis of speculation or hypothesis. In one sense, this is a fact-specific case, but in another sense, there's a larger point at issue here, and that is that this circuit and the Ohio River Valley in particular, but South Carolina as well, are suffering from a very serious a drug crisis, a very serious opioid crisis. It's very hard to get on top of it. It's proved incredibly stubborn. And one of the tools with which this is fought are civil forfeitures. Do I like civil forfeitures? No, I don't like them. But Congress, when it shifted the burden of proof, did not repeal the preponderance standard, and it did not take away the probable cause standard. It still left the statute intact. And it does seem to me that this remains, even if distasteful, one of the means by which the opioid crisis is combated. And if we start hollowing that out, we just make it more difficult for the elected branches of government to use even this tool to make headway against it. And, there's always, we've got a problem on our hands, and I would be sympathetic entirely if I thought the case was plausible. But it seems to me that what you've been talking about is explanations for the misconduct here is a stretch. Go ahead, counsel.
I see that I'm out of time.
That's all right. I took some of your time, so you go ahead.
Okay, thank you. Well, Your Honor, one of the, with all due respect and with recognition that there are reasons that civil forfeitures are in place, the reasons for the reform are just as important. And one of those basis for reform is that in cases like this, where there is not definitive evidence of drug trafficking, the people should not be subject to having their property taken without evidence that not just that it's possible that they were involved, but that.
But that's a very general
proof. That's one of the reasons.
The problem is it doesn't begin to grapple with the specifics here. And if it was just one of these pieces of evidence, it would be something. But it's just when you add one piece of evidence to another, then the overall case is simply more condemning than any particular part of it. That's the thing. And this is a divide and conquer question.
Well, Your Honor, one other thing that I did want to bring to the court's attention is that the government's expert who came to the conclusion that it wasn't possible for Mr. McClellan and Ms. Silver to have this amount of money was not provided with any information regarding this large sum of cash that Mr. McClellan inherited, or the fact that in determining what his day-to-day expenses, that family's day-to-day expenses would have been, the fact that they were in a home on which they had no mortgage. And the expert did note in his report that any additional information that might have come to him could have affected what his ultimate opinion.
All right.
Thank you.
Well, we thank you, Ms. Turner, and it's regrettable that we're not able to come down and shake hands with you, but we appreciate every one of your arguments and thank you for being here this morning. We'll now proceed directly in you're ready.
May I remove my mask?
Yes, you may.
Good morning, and may it please the court. My name is Graham Bryant, and together with Jordan Minot, Assistant Solicitor General for Virginia, I represent Harold Clark, Felicia Stretcher, and Richard Davis in this interlocutory appeal from the district court's decision denying qualified immunity. I'd like to reserve 5 minutes for rebuttal as well. The district court misapplied the circuit's precedent for determining whether the law was clearly established for qualified immunity purposes. And in doing so, it elided the hard part of the case, and it got the qualified immunity analysis backwards. It concluded, based on the absence of evidence, or the absence of precedent, rather, that the government lacked a sufficient interest in testing Garrett. This was error. I plan to focus my time today on showing how the district court misapplied the clearly established analysis. Under a proper analysis, no controlling or persuasive precedent placed the appellants on notice that applying the random drug testing policy to Mr. Garrett violated.
In focusing on the clearly established business under Pearson v. Callahan, we can do either the merits or the clearly established. I'm sort of surprised that you wouldn't just go after the merits, because if you went on the merits, ipso facto, you'd win on clearly established.
Absolutely, Your Honor.
You're not giving up your argument on the merits, are you?
Certainly not, Your Honor. We believe firmly that we would prevail on the merits or under clearly established.
Can you, before you turn to the clearly established part, can you talk to me a little bit about what I do with the consent in the employment agreement? I mean, there seemed to be like a little bit of divergence across the courts on the degree to which the consent matters, ranging from it sort of resolves the case in your favor to it sort of doesn't matter. Can you talk to me about what that means for your analysis?
The primary role of Mr. Garrett being fully aware through policy 135.4 that he was subject to random testing, and that if he either left before the test was complete or otherwise refused testing, he could be terminated, that dramatically reduced his expectation of privacy in this context.
Okay, and when you say the policy, what is that something he agreed to, or is that something that was imposed on him? Like, did he sign something when he became an employee that acknowledged he was subject to drug testing?
Yes, Your Honor. He signed a document acknowledging that he had received and reviewed the policy and consented to it.
So it's not really that there's a policy, right? It's that he agreed to it.
Oh, absolutely, Your Honor.
Right. But your point is that it's only pertinent in evaluating the degree of his expectation, not that it's like we think about in other contexts. When someone consents to something, it doesn't change their expectations. It just means that there's consent, right? If somebody walks up to my door and asks to search my house, when I consent, it's not that my expectations have changed. I've just consented. I have no Fourth Amendment claim once they walk in my house, as long as they act within the scope of that consent.
Of course.
So why are you not arguing that suffices here, that consent just simply resolves it?
Well, the consent honestly could resolve it, Your Honor.
I know, but you haven't argued that, and I'm curious why is what I'm.
Well, under the CATS framework, everyone always has a Fourth Amendment expectation of or a Fourth Amendment privacy interest, and depending on the circumstances in that person's specific factual situation, reviewed in the totality of the evidence, that expectation can, or that interest will always remain, but the expectation of it can get lower and lower and vanish. And the consent here, by consenting to it, Mr. Garrett did functionally give away his expectation of privacy. He opened up his Fourth Amendment privacy interest to the search that took place, or would have taken place here had he remained. So yes, we believe that by consenting to the test, or by consenting to the policy, he functionally waived any privacy interest he would have. So on the Fourth Amendment balancing test, there's next to nothing on Garrett's privacy interest side.
So let me ask maybe the same question is, do you think that if I had a purely administrative person, so imagine one of my law clerks in the back, right? And I make them sign a piece of paper when they show up that they're subject to random drug tests. They may do this already, I don't know. But I gave them a piece of paper and I said, no, in order to work for me, you have to agree to random drug testing. And even though I think under Skinner and Von Raab, they're not the type of people for which there's a special need, if they've consented to it, is that okay?
I believe consent should be enough. And certainly in this case, there's the confluence of factors that are all coalescing into just a melange of special needs that surround Mr. Garrett. In addition to being a safety sensitive employee who has access to maintain the information technology and network infrastructure of the Department of Corrections, he also, by his own admissions in the complaint, he is affirmatively alleging that he has contact with inmates, both at headquarters and when he's out on the field. So collectively, at any point in which Mr. Garrett is doing his job, he has contact with inmates.
What it was, you suggested, and then I'll stop and I'll let others, but you suggested there that his access, I get the part of inmates, but the access to confidential information, that itself is a special need. What's the best case that you've got for that suggestion?
It is. The Von Raab case obviously did not fully decide the issue. It acknowledged that it needed to remand for additional facts on that. But then there's other case law, including from the DC Circuit, that has held that at the core of special needs, at least, is top secret confidential information. So just looking at those two cases, there's kind of a range of information that could be considered sensitive information as a privacy or as a special need. And our view certainly is that nothing in the case law would have put the defendants here on notice that access to the information technology backbone of the Department of Corrections, contact information for correctional employees, that would not be a sufficient privacy.
Well, I mean, Mr. Bryan, apart from I agree that the consent is relevant here, and I think it certainly weighs on your side. And but it seems to me the larger point is that the prison environment itself establishes a special need for drug testing, and there have been innumerable circuit decisions that have upheld drug testing programs on that basis. And what happens is this: these drugs are the most they pose the most clear and present danger to order within the prison environment. Because what happens here is you get a good number of inmates, many of whom are incarcerated for drug-related offenses, and they recreate within the prison environment the same environment that they were operating in on the streets. They learn the tricks of the trade on the streets. They learn how to operate. They learn how to establish their turf. They learn how to coalesce into groups and gangs. And then they transfer all of that knowledge into the prison environment and recreate it with all of the tricks of the trade and what else. And it poses, on balance, a really significant threat to prison order and discipline. And to sort of tie the prison's hand on combating what is the major problem within that environment is just almost to encourage a degree of lawlessness above and apart from what is already there.
Absolutely, Your Honor. That is certainly our position. And I think the facts that you just mentioned about how the correctional environment in some ways comes to replicate the street, so to speak, that also speaks to why so many of the cases describe the risk of drug smuggling arising from the mere contact with inmates. So even if Mr. Garrett does spend most of his time at headquarters, he's alleged there are prisoners that are there at headquarters. By developing relationships with these prisoners or any type of situation that could expose him to compromise the security of the Department of Corrections, either through blackmail, friendship, what have you, anything that could lead him to compromise on those principles is a severe danger to the Department of Corrections and that department's mission. That's why this policy is here.
Before you get too far down the road on these various factors, I wanted to just circle back to consent and give you a chance to respond to what I think will be your opponent's argument about courts who have said that you can't condition employment on on agreeing to an unconstitutional search. right? They cite an Eighth Circuit case, et cetera, for that. So what's your response to that here, that the consent doesn't count for as much as you claim because you can't require someone to consent to an unconstitutional search?
Our response would be that the search is not unconstitutional.
Right, so the two are tied together. The consent doesn't stand by itself. It depends on your argument that this is constitutional.
I believe to a certain degree it would have to. I think, again, the consent's effect, if it does not outright eliminate the Fourth Amendment problem, what it does do is ensure that Mr. Garrett's privacy expectation is so minimal that the substantial interest that the Department of Corrections has on the other side of the balance, all of the special needs from sensitivity to contact with prisoners, the safety sensitive interests, all of those that we've outlined in our briefing and on argument far outweigh the expectation of privacy on the other side of the balance, such that the consent, to the extent it does work, means that there really is no violation.
It's bound to have some relevance. It may not be conclusive in itself, but it's bound to have some relevance simply from the fact that innumerable car searches, for example, are allowed under a theory of whether the consent was voluntary under the totality of the circumstances. Now, it may not be an exact analogy to the prison, but surely informing someone and letting them and asking their consent is better than not informing them, even though it may not be conclusive by itself. Surely we don't, letting someone know what the conditions, terms and conditions of employment are is better than keeping them in the dark.
That is correct. Mr. Garrett voluntarily chose to seek employment and received employment in a highly regulated field. Corrections are perhaps the most highly regulated field known to the law. It's a place where if you go to visit a prison, even not being a prison employee, by parking in the prison parking lot, you generally are consenting to a search of your car. Those expectations are substantially lower in the context of corrections. And that's why the district court's decision that the law was not clearly established is error. No case, certainly no controlling case, says that the policy as applied to Mr. Garrett was unconstitutional or would have even begun to put the individual defendants on notice of that.
But if we go on the clearly established business, there's some problems with deciding cases on a clearly established basis because the prison system, the correction system, has an interest in knowing whether these random drug searches are legitimate or whether they're not. And if we sort of weasel out and say, well, it wasn't clearly established, but it might be at some point in the future, you probably, you've gotten a winning case, you've gotten the result you wanted in a particular case, but you still left the prison system and the corrections department in a state of complete uncertainty. You see what I'm saying?
Certainly.
Go for the merits.
And we firmly believe that this is a case where the Department of Corrections does prevail on the merits. Our point is, at an absolute minimum, the individual defendants here should not be subject to individual financial liability for applying a policy that seemed constitutional.
That's right, but that's your fallback. That's your fallback. And you don't want to, the thing about a fallback position is you don't want to fall in the first place.
Of course. And in this case, again, the test was constitutional because it was minimally invasive. A buccal swab is the least minimal or the least invasive way of doing these tests that the law has established. It's certainly less invasive than a urinalysis or a blood draw. And it's random. The cases have held that random testing is more effective at accomplishing the purpose of the test than a scheduled test that might be predicted. The special needs we've discussed, they are overwhelming in this context as concentrated in Mr. Garrett. And his privacy interest is minimal. Given those reasons, there was no Fourth Amendment violation here, and certainly qualified immunity at a minimum should apply. But again, our position is there was no violation of the Fourth Amendment. Unless the court has any other questions, I'll reserve my remaining time for rebuttal.
All right. We thank you. And Mr. Allen, we'd be pleased to hear from you.
May it please the court, my name is Robert Allen. I represent the grievant, or the appellee in this case, Jacoby Garrett. I'd like to first address some of the issues that were raised in the argument. As to consent, the McDowell v. Hunter case from the Eighth Circuit holds that if a search is unreasonable, an employer cannot require an employee to consent to that search as a condition of employment.
Wait, so, all right, but why, right? I understand the 8th Circuit or 10th Circuit, whichever one, said that you cannot condition employment on a drug test, right? And I frankly have a little hard time understanding that. I understand what I believe Judge Wilkinson's point was. You got to evaluate whether the consent is voluntary. And maybe there's some scenario where it's so coercive that it's not voluntary. If you already worked there, for example, right? But if it's done before you accept employment and you're aware of it, we don't typically think of those as being involuntary or coercive consent, right? And no more than we consider, the consent or agreement to plead guilty as the waiver of your rights to a jury trial to be involuntary because it carries prison one way or the other, right? So what I don't understand is why you can't consent in the employment context. Is it something that's so sacred about government employment that you have like a constitutional right to be a government employee? Or why is it that you can't consent to Fourth Amendment searches?
That's what the law from the Eighth Circuit holds. I don't think there's. And
you understand that doesn't control us, right?
Certainly. Now, when you talk about consent in terms of the search of a vehicle or something like that, that's a different scenario because you might have reasonable suspicion, you might have probable cause. In this case, we need to consent.
Well, but you get consent when you have neither of those, right? That's why you ask for consent. If you're an officer and you say, can I look in your car? One of the reasons to ask is because you might not have reasonable suspicion or probable cause, right? So if you get consent, you don't need those.
Well, in this case, there's some question as to what agreement or what drug policy was actually agreed to. It was amended around the time of his drug test. But setting all that aside,
did you make? I mean, was that a contested issue below?
It's in the complaint. I don't think that it's overly significant because the Department of Corrections has had a policy for many years that has required the drug.
The wording might change, but they've all required drug tests.
Right. So the policy could require a variety of drug testing. Any kind of drug test you could imagine, blood test, urine test. Of course, it could be a test that's done after an accident as part of an investigation. It could be a pre-employment drug test. My client took a pre-employment drug test and passed it. But what this case involves is a suspicionless random drug test.
Well, but let me ask you this. What is the problem here? One of the things that we look at is how intrusive is the search. And, if they were drawing blood, one thing. If this were urinalysis, maybe one thing. Certainly, if it were a strip search, I think that would be the most humiliating of all. But what in the world is so invasive about a facial swab? I mean, it doesn't. What is the big deal? I mean, because one of the things that you look at in establishing Fourth Amendment reasonableness is the method of any kind of intrusion. And I suspect the facial swab would be the least intrusive of methods of conducting this.
It's not in the record what type of test this would be.
Are you disputing the fact that it was a facial swab?
There was no test in this case. Under the facts of this case, my client was.
But would it have been a facial swab? You don't say that it wouldn't have been. The state contends it would have been.
I believe that it most likely would have been. I can't say with certainty what it would have been.
All right. Well, let's say it. Okay, you believe it most likely would have been, and I appreciate your candor. But why? I mean, what is the? Just to put it in the vernacular, what is the deal when we're doing a facial swab? I mean, if they were doing a blood test or whatever, or the Supreme Court is actually in Schmerber allowed more invasive kind of things. But it seems to me here, the Department of Corrections deserves some credit for having a random testing program that relies on less rather than more method of testing.
Well, that's where I disagree, Your Honor, respectfully, because the Department of Corrections has a policy that requires drug testing of every employee, regardless of what they do, regardless of their duties, regardless of whether they're involved in a...
That's fine. And if it were selective, you would have a problem there. And you would say, well, they were treating people unequally. So what departments of correction have done is they've gone into random tests that don't run the risk of racial profiling or some sort of profiling. If they apply it to everyone, that's the most even-handed thing they can come up with, isn't it?
Well, I disagree. I think it's the most unconstitutional way to approach it. In this, if you look at the Taylor case from the Seventh Circuit, very similar facts dealing with Department of Corrections employees. And the court held that the only employees that could be tested are those in safety-sensitive positions. The Department of Corrections in this state requires testing of everyone. The other people that were tested along with, were selected for random testing along with Mr. Garrett, there was a personnel assistant, and a construction assistant, HR personnel. None of these people have any safety-sensitive role whatsoever.
Sure. Well, let me ask you about that comment that you just made. You say none of these people had any safety-sensitive role. Are we then to take this policy and go job by job by job by job and say, well, this one can be tested, but that one can't be, or this job involves a greater degree of contact with inmates than that job? And if we go job by job by job, which, I mean, in many instances, fact specificity and narrow rulings are very, very helpful. But in some, they have real pitfalls. And what I'm concerned about here is that by going individual job by individual job and asking what the characteristics of each and every job are, one of the things that we have done is you get into micromanaging. And it's the job of the prison administration to decide which jobs do and which jobs don't. And if we start saying this job qualifies for random drug testing, that job fails to qualify for random drug testing, then we've become prison micromanagers, haven't we?
Well, Your Honor, that you do have to go into that analysis of what the person does, whether their job is safety sensitive. However, I do not think that it would be that difficult to draw the line. For example, certain state employees are designated as classified. Certain ones are designated as safety sensitive.
Oh, but all of those judgments would be subject to litigation if we went this route. That the safety sensitive determination in this particular instance was unwarranted. We just opened the door to litigation.
Well, I think there's some bright lines, and other courts have drawn the bright line for within the corrections industry. The employees that can be subjected to random drug testing are employees like prison guards, those that carry firearms, those that are involved in drug interdiction, those that are supervising or transporting the inmates. Those are safety sensitive positions within the...
So, but you've just drawn up a prison administration code. We'd have to go job by job. And you know, that's what, that strikes me, we're sort of drafting a code or a set of rules.
Well, the code or set of rules that you're referring to really already exists. Each one of the employees that works for the state has an employee work profile that sets forth the employee's job duties, what their responsibilities are. In this case, Mr. Garrett had a checklist of programs that he was able to have access to. Chorus was one of them. It's an inmate management system. The only program that Mr. Garrett had access to was Outlook and Excel. I mean, those are basic programs. He simply was not involved in supervising or detaining, transporting inmates. He didn't carry a firearm. He didn't even.
Well, on the other hand, you can point to that, and they can point to the fact that he has a state car and he has contact information, and he does circulate with some of the inmates at headquarters and everything. And this, I'm just afraid of becoming a minute balancer in this kind of situation, where I think the precedent of a number of circumstances in applying the special needs provision indicates that the prison provides a special need, in which case the latitude for this kind of drug testing is greater. And I think the circuits have gone pretty far in trying to uphold this and not put ourselves in the position of a prison administrator. And if we started quoting that language, it's in our practice, it's in dozens and dozens of cases. We'd be creating something of a riptide if we started undercutting the notion that a prison environment represents a special need.
Well, as a matter of fact, my client really did not work in a prison environment per se. He worked at the Department of Corrections headquarters. 70% of his work was troubleshooting employees' cell phones. And that's all alleged in the complaint. Now, in the appellant's brief, there's references to the use of a vehicle, other things of that nature that really aren't in the record below. Those are cited from the hearing officer's decision. Every fact finder that has looked at the facts of this case has found that Mr. Garrett could not be subjected to drug testing. That includes the hearing officer.
Did he undergo a physical fitness testing when he began his employment?
I don't know the answer to that. But the hearing officer found that it was unconstitutional. The Office of the Employee Dispute Resolution didn't find any reason to upset that decision. The circuit court found that it was unconstitutional based on all these facts that were developed during the grievance and the same facts that will be developed during this case. The Court of Appeals the State Court of Appeals has now remanded it, which I have appealed to the Virginia Supreme Court. But there hasn't been.
I mean, we have a federal question before us, and on the other side of things, you can pull out decisions from the 10th and the 6th and the 7th and the 8th Circuit, and the cases all involve this or that circumstances, but they all involve drug testing in the correctional environment. And it does seem to me that the courts have given some respect to that.
I would agree with that. And I would agree that the courts that have looked at it have gone into an analysis of the employee's job duties. What do they do? Certainly, if Mr. Garrett was a correctional officer, we wouldn't be here. That's clearly a safety-sensitive position where she could be subjected to random drug testing under established precedent.
Can I go back for a second just to the context of consent, right? And so the 8th Circuit decision says that you can't condition employment on it. Are you aware of any instance where a court has applied other than that case, that's applied the unconstitutional conditions doctrine in a Fourth Amendment context? I mean, we think about it in the First Amendment context regularly, right? Occasionally we see it in like the Fifth Amendment context. Maybe it's shown up in the due process context from time to time. But I can't think of an example where the unconstitutional conditions doctrine has been applied in a Fourth Amendment context. Can you think of an example that I should look at? I mean, the cases the 8th Circuit relies on are First Amendment cases, right? A teacher conditioning on their speech, right? Okay, we can sort of debate what that looks like, but I can't think of one where they've done it in the Fourth Amendment context, where we've extended that doctrine, whatever its pedigree, to this particular context.
I can't say that I can think of a case sitting right here. I will say with the consent, I think a person can consent to a number of things, but I think you have to look at when the drug test occurs as to see whether it's unconstitutional. You have to look at what type of test it was, and what was his role at that time. So when you look at the facts of this case, it was a suspicionless random drug test, and he was not involved in any safety sensitive position with the Department of Corrections. So as for clearly the issue of when a law is clearly established, there does not need to be a case that's exactly on point. So you can, first you look to the highest court of the state. There's no Virginia Supreme Court case. There's no Fourth Circuit opinion that's directly on point. However, when you look at the cases that have been decided, you look at them collectively, the cases of Skinner, Von Raab, Chandler, those Supreme Court decisions established that for a random, suspicionless, or warrantless drug test of a government employee to be constitutional, the employee must hold a safety-sensitive position.
Well, if we went there, why doesn't the access to confidential information for fellow employees and supervisors, the use of a state car and the freedom that he has to circulate from one place to another, why isn't that sensitivity?
Well, I don't concede that he had access to sensitive information. The record in this case is pretty thin at this point. It's based on the allegations of the complaint. But the information that he had access to was a cell phone database. That's not necessarily personal information of employees. It's basically their work phone number.
Why do you say that? It would strike me that it was private, sensitive information.
Well, even if it has some degree of sensitivity, it doesn't arise to the truly sensitive nature of information, as in the Von Raab case. Now, in that case, the court held that even grand jury information was not truly sensitive. The information that was sensitive enough for an employee to be subject to random drug testing was information on drug interdiction plans, names of informants, things of that.
Well, if somebody's driving around in a prison environment and they have access, they have my cell phone information and they have my contact information and they have my cell phone information and contact information from all the other employees or however many other employees in the prison system, that person would seem to me to be, the kind of individual that have the kind of information that other inmates might be very interested in, because it would increase their ability to coordinate. If you've got everybody's cell phone number and you've got everybody's contact information and you want to establish some kind of coordinated drug activity, having that kind of information on hand would seem to me to be very useful.
Well, the extent of the information that Mr. Garrett had access to is not that well established in the record at this point. In his job description, it talks about managing a database. And again, the evidence would have to show exactly what that database is. But the information that he had access to doesn't come close to what Von Raab has described as truly sensitive information.
Well, but what I'm saying is that anybody, information is power, and anybody that has information that everybody else's cell phone number and everybody else's contact information and the rest, if I were a person of some influence in the prison environment, I'd love to get my hands on it, because I could make all kinds of calls to all kinds of people and coordinate all kinds of activity. So this is what I'm worried about. To get into these micro arguments as to whether the possession of a state car and whether the degree of contact and whether the amount of contact information and cell phone information is sensitive or not. I don't know why courts are deciding these questions. It's not our bailiwick.
Well, Your Honor, I see that my time has expired, but I'm happy to answer your question if I may.
All right. Thank you very much, sir.
All right, thank you.
May it please the court. This court is welcome to disagree with the Eighth Circuit. Eighth Circuit precedent does not bind this court, and we think, to the extent the court would like to, it should. But the court need not reach that issue, and because we stressed qualified immunity to avoid line drawing issues. This court need not become a minute balancer unless it chooses to dig into those issues. At bottom, my friend on the other side's argument shows that it wants this court to make the same mistake that the district court made, which is to get the qualified immunity analysis backwards and find that because no case specifically approved of the exact testing used in the exact circumstances here, that the testing was clear, that its unconstitutionality was clearly established. That's not the test. Instead, undoubtedly, Garrett here had a plethora of conditions that established that the Department of Corrections had special needs to test him. On the other hand, Mr. Garrett consented as part of his employment. He alleges in his complaint, without looking at any other facts that may or may not be in the record, his complaint alone alleges that he had contact with inmates and access to network infrastructure that can be reasonably construed to involve access to sensitive information. Under the same precedents that he pointed to that are controlling precedents, that's enough for the Department of Corrections to believe that its testing policy was constitutional. And again, we don't just believe that it was constitutional. Our position is that it does not violate the Fourth Amendment. The method of testing, likewise, was as minimally invasive as possible. Rather than urinalysis or blood draws, which are the types of tests discussed throughout the precedent, the Department of Correction used a buccal swab for its tests. That's the most minimally invasive test recognized. And this is not a scheduled test or an individualized suspicion test. It was randomized. Of a test without individualized suspicion, random testing is the most approved method. So for these reasons, we ask this court to reverse the district court's rulings and find that there was no Fourth Amendment violation. And certainly that if there was a Fourth Amendment violation, qualified immunity protects the individual defendants in this case. Thank you for your time.
Of the appointment of the administrative law judge in 2017, when we had the opportunity to raise it before the board, had we done that, it was, again, it would have been futile to raise it before the board. They had no authority to decide it, and that is typically a defense to forfeiture. Now, in your decision in First Citizens Bank Corporation versus Camp, which is a Fourth Circuit 1969, the Fourth Circuit observed there can be no sandbagging where the challenged defects are not correctable at the administrative level.
I guess your argument is presuming that we can judicially create a exception to a regulatory exhaustion requirement. Are you arguing that we can create an exception to this exhaustion requirement that is in the regulations?
I don't think we violated an exhaustion requirement. First of all,
you're arguing you're arguing an exception here. It sounds to me like you're saying that you didn't exhaust in the front of the board the first time, but it was excusable. There's an exception because the law was not clearly established in your favor. Right? That's your argument that you're making right now.
Not exactly. First of all, because it's a constitutional issue involving a question of core constitutional principles, I don't think that there is an exhaustion requirement in the regulations of the board or of the administrative law judges.
Wait a minute, people forfeit constitutional issues all the time by not raising them. If you don't raise a Fourth Amendment argument or Fifth Amendment argument or whatever, those are generally subject to to forfeiture, but the fact of the constitutional nature of an argument, that by itself doesn't provide an exception to forfeiture rules.
Well, I think it does provide an exception to forfeiture rules, but I don't think that we forfeited it. It wasn't really an active issue in
All right, so let me ask you a slightly different question, right? So you're arguing, oh, the nature of the claim or what we knew, right? So let's pause it for a minute that those are off the table, that you lose on those. I really thought the argument you were going to make is different, or that you were going to focus on is different. And I thought what you were going to say is, yeah, there's a board exhaustion requirement, right? So in order for the board to consider something under 802.301A, there has to be some exhaustion. But before the ALJ, the exhaustion looks different, right? And the ALJ has a limited exhaustion requirement, right? That says that you have to have a contested issue unresolved by the district director, right? And you hadn't raised the issue of the appointment before the district director. But of course you wouldn't raise the question before the district director because it wasn't ripe yet. You hadn't been assigned an ALJ. And that's why there's an exception in those for issues that could not be addressed by the district director. And so, in fact, it seems like to me what you really are trying to say is not that it's an exception. We don't care one iota what the issue was, whether it's constitutional or raised or not. When we went back to the ALJ, there was no exhaustion requirement that we have raised it before the district director. And we were starting afresh before the ALJ. That's what a remand does.
That's my point. And I said that I didn't think we had forfeited under the rules because under the administrative law judge's rules, you can raise any argument for the first time before the administrative law judge.
Right. And so the
real do it in writing, which we did immediately.
And the real exception here is not being sought by you, but is instead being sought by your proponent, your opponent, who says on remand, you ought to be limited to the issues that you previously raised. And that might be a very good rule. We might well like that rule, right? But we have to find it in the regulations, and it doesn't exist in the regulations. Like that rule that on remand, you're limited to issues that were raised previously might be a very sensible rule. In fact, the agency might well adopt such a rule, but there's not one now. And so we can't make it up. And that's what your opponent is asking us to do, not the other way around. I understand you have this alternative argument about it's constitutional, and I really couldn't figure out what was going on, but those are secondary arguments, it strikes me. The primary argument is the regulations don't require you to have raised it on the first go around once you're back at the ALJ. You get a chance on remand to raise whatever you like. In other words, the mandate rule doesn't limit you to arguments that were raised before once you're back on remand.
I agree. That's our argument. We made the argument in the brief.
Well, but you were permitted to raise it. Whether you're required to raise it is one thing. You were certainly permitted to raise it.
Well, we did raise it before the administrative law judge immediately upon remand. This is intervening authority. And the law of intervening authority in black lung cases, I think was...
Well, I think your position would probably open up a split with the other two major black lung circuits in the country, the third and the sixth. And it would have a bit of an untoward effect here. This case, in the average black lung case, takes 22 months to resolve. Many of the recipients of these benefits are people of advanced age, and they are suffering from diseases involving inflexible lungs and a shortness of breath. And having a shortness of breath is perfectly miserable. And you want a rule, you want us to create a rule that allows you to bypass the remedies before, or the chances that you had before the ALJ and the BRB, and take this person and go all the way back to ground zero and say the last 2 years amounted to nothing. You don't get your benefits after all. At this point, allowing this sort of untimely proffer of objections seems to me a way to gum up the system and induce delay in a system that by its very nature has layer after layer after layer of proceedings. And we would, I think, be doing that against the director's view and against the Third and Sixth Circuit's view. And I just wonder what we do to the whole system when you say, oh, people can sit on their rights until they learn they have an adverse decision. And if we create a rule that says you raise, in order to preserve a rule for the next level up, you've got to raise it earlier, that raising something earlier preserves it later. And if we say that that is a rule that is perhaps one of the most common rules in any kind of procedural system, that in order to preserve an argument for the next step up, you have to raise it below.
Well, Your Honor, I disagree that that's the law. I don't think that the law excuses violation of constitutional rights based upon these prudential concerns, and even the Sixth Circuit wouldn't go there. And the basis for it, which is the L.A. Tucker truck lines case, it never really had any foundation. It hasn't been applied in a majority opinion by the Supreme Court.
Well, so I thought what you were going to say was slightly different, which is the Third and the Sixth Circuit, we actually might well agree with them, but our case is different because of the remand. Both the Third Circuit case and the Sixth Circuit cases were instances where the issue was not raised before the board and then came directly to the Court of Appeals. And we said the board has an exhaustion requirement. We agree with that. But neither of those cases involved this remand. So you might well make the argument the Third Circuit and the Sixth Circuit are exactly right, but that doesn't control this result. It's not a split at all, is it?
Well, no, I don't think it's a split, and I don't think our case is like the Third or the Sixth Circuit case. And I don't think these issues were raised in the Third Circuit. It's an unpublished.
It wasn't that it wasn't raised. Yeah. It is the facts didn't exist there. There was no remand,
right?
And so you weren't back before the ALJ, and so it could not have possibly been raised, given that it hadn't happened.
That's correct. I agree.
Thank you, Mr. Solomon.
Well, I'm sorry.
We'll hear from Mr. Goldberg.
Hello, thanks for having me. May it please the court. My name is Jeff Goldberg, representing the Director, Office of Workers' Compensation Programs. And this is really a fairly straightforward case. The facts are that the appointment clause has been around since June 21, 1788. Ed Potter did not raise an appointment clause challenge to the ALJ, did not raise an appointment clause challenge to the board, even though Lucia had been decided 5 months before the board's decision, even though all of the Department of Labor had ratified all of the ALJ's appointment 11 months before the board's decision. And the law is pretty clear too. Appointments clause challenges, where they are as here as applied, are non-jurisdictional and subject to forfeiture. Lucia and Ryder both say that appointments clause challenges must be timely raised. So what is timely under the black line?
Right, so I wanted to give you a chance to give an overview, but I want to get to this point, right, and try to understand. Point me in the regulations where the regulations require that issues raised on remand must have been raised before the remand, either to the ALJ or the board.
That's not a regulation, Your Honor.
Okay. But I just want to make clear, there is no regulation that requires that.
No, but in the board's remand decision, they order the ALJ to reconsider these and only these issues. In this case, it was the minor's entitlement to benefits because they had already affirmed Ed Potter's status as the responsible operator.
And so your point is that your argument is that at J93, where they issue the remand, that created some sort of a forfeiture, right? The scope of the remand created a forfeiture that's not in the regulations?
No, the forfeiture was created when Ed Potter failed to properly raise it. They are required to identify issues to the district director, The ALJ can only consider those issues, and he didn't raise it before the ALJ, and he didn't raise it before the board.
Understand, but why on remand? What I'm getting back at, and then I'll let you go ahead and talk about whatever else you want to the extent that you're more interested in those things. But what I don't understand is why on remand, and I understand your argument about J93. You can hypothetically assume that I don't buy it, but maybe others will, right? That created a forfeiture. But if there's no regulation that limits the issues to be raised on remand to those that have been previously raised, right? If there's no regulation, it might be a good idea. It might serve great policy goals, but my job is to determine what the board's actual forfeiture rules require, what the actual regulations require. And you agree that there's no such regulation.
Not specifically directed to remand, but the regulation.
That's the case we've got, right, is on remand.
Yes, but once you fail to raise an issue before the board, it's forfeited.
And why? Tell me why that is, because the board's forfeiture says we won't consider it. That is, the board won't consider it.
Right.
It doesn't say, nor shall it be considered by the ALJ on remand. That's not what the regulations say.
No, it doesn't. But the ALJ in this case was ordered by the board, a superior authority, to consider only the specific issues that the board directed the ALJ to consider.
Okay, but neither the ALJ nor the board made that argument, right? Like the ALJ said, what you agree there's no regulation on, which is you didn't raise this the first go around and you can't raise it now. And that's what the board agreed with. You're now saying the scope of the remand requires forfeiture. I understand that argument, but that's not the argument that was accepted below.
That's not what I'm saying. I am saying that Ed Potter's failure to raise the issue to the board created forfeiture.
And can you explain to me under 802.301A why that is? Like pointing to the regulation, why under the text of the regulation that forfeited issues on remand?
Because, well, first under 802.211 and 802.301, the petitioner is required to present its arguments. The arguments have to arise from the ALJ's decision, and they have to be supported by argument in fact. Mm-hmm. There was no argument regarding the appointments clause.
And just like in the Third Circuit, or the Sixth Circuit, if that had been the argument that had been raised, right, and the board had said, you didn't raise this before us, that's fine. But here it went back down, right? It didn't stay there. So the board could have made that argument, but it didn't. It's remanded on other issues.
Well,
right? And then the ALJ has a fresh crack at it.
If you were to remand, say, a hypothetical case, or this court were to remand a case, and you said, we affirm findings A and B, but we didn't want further consideration of C and D, the judge below would not be free to do A through D and maybe F and G as well.
But in the petitioner's argument, Mr. Solomon's argument here, does it deny altogether the ability of a procedural system to fashion procedures that it's necessary to raise something at a lower level in order to raise it, in order to preserve it for a higher level? Is it Mr. Solomon's view that, in your judgment, that he is denying the ability of the black lung system to engage in these sorts of procedural steps, that in order to preserve an issue for a higher level, you have to raise it first at a lower level? That would seem to me to be sort of meat and potatoes procedure.
Right, exactly. This is a constitutional issue, but constitutional issues, as you pointed out earlier, can be and often are forfeited.
But I mean, the question is whether the system itself, the administrative system, and the director have the ability to fashion procedural steps, which are among the most common in every procedural system, that you have to raise an issue earlier in order to preserve it later. And that's just a bedrock of procedural efficiency. And what I think that I'm concerned that Mr. Solomon's position comes close to denying the ability of the system to take that step. You understand what I'm saying?
And I agree, Your Honor. 30 U.S.C. 932 gives the Secretary of Labor the power to promulgate regulations, and these regulations are in terms of issue exhaustion, are of the type that every first-year law student learns. You raise an issue below. If you lose, you preserve the issue, then you argue it before the appellate court.
Yeah, but what I'm saying, true. I mean, I hear exactly where you're coming from. Normally, procedural regulations are statutory or regulatory, but not invariably. For example, we have local rules and all the rest. But the question is, even if the statutes and the reg are silent, it is okay to impose or to have a procedure that serves the interest of the system in advancing administrative efficiency. That is at the heart of what we do. And just to say that the administrative system here works some sort of injustice on the appellant, it just doesn't seem to me that even where there is no statute or no regulation, it is not out of bounds to have a view of preservation of an issue, that you do it sooner rather than later, because sooner rather than later is essential to allowing every ALJ, every district court, every board of benefits review the chance to take a look at this in a timely fashion, and not to have to let litigation dribble on and on by people who don't raise something in a timely fashion and raise it only after a remand when they don't like the result. And in particular in this system, to adopt that kind of view is simply going to add to the extraordinary delay that already attends these proceedings. As you point out in your brief, it takes 22 months to get one of these things resolved. These are elderly people, and they have worked in the mines, and their lungs are shot. They're inflexible, and and many of them are frankly struggling for breath. And we are going to deny the system the most minimal ability to expedite the consideration of their claims. You see my concern?
Yes, we do, and we absolutely agree with you. The regulations require issue exhaustion, just like most systems do. This isn't a case where say with Social Security, which doesn't contain an issue exhaustion scheme, the regulations here require it, and it's
okay. Now tell me what regulations require it. You just cite to the regulations that require issue exhaustion, okay?
Yeah, 802.211, 20 CFR 802.211.
Do you agree? Do you agree? So I very much accept Judge Wilkinson's good point that if the regulations or statutes don't include it, we can, under McCarthy versus Madigan, imply issue exhaustion under certain circumstances. But my question is, do you agree that where the regulations include some issue exhaustion, that McCarthy versus Madigan does not permit us to supplement those? In other words, we have to, whatever they are, you may be right, I may be right, I don't know, but once we decide what those regulations are, McCarthy versus Madigan doesn't allow us to supplement whatever the regulations are, given that you have regulations in place.
Well, if you were to describe that, I think prudential issue exhaustion would be appropriate.
No, but that's what I want to get at, is McCarthy versus Madigan is for the context in which there is no statutory or regulatory issue exhaustion. where the director here has chosen certain issue exhaustion requirements in the regulations, and we can debate what those are, but we know what they are, right? The provisions are here.
Yes, they're in.
Then McCarthy versus Madigan doesn't let us supplement those, right? Because your agency has made choices about what regulations and issue exhaustion to enact, and they have enacted some, and it would be a gross use of our power to like go in and be like, yeah, but we really need to add these couple, right?
Right, but our issue exhaustion requirements are at every level, from the district director to the.
Oh, I understand, but I just want to make clear, your argument is we get them from the regulations, not this sort of McCarthy versus Madigan, make it up as we go approach.
Right, although, again, prudential issue exhaustion would be appropriate here, just because, unlike, for example, Social Security, ours is an adversarial scheme, and parties are expected to develop their issues, which is not the case with another.
But the point is, you're saying
it's not an issue exhaustion.
You're saying here, and I want to make this clear, you're saying here that you have required issue exhaustion by virtue of the regulations.
Yes.
And that you're saying that even if you hadn't done it for this specific thing, that in the interest of procedural efficiency, you have some prudential latitude. Now, you don't have complete prudential latitude because, but what the latitude you're asking here is that you raise an issue first to preserve it later. There isn't any more basic proposition for procedure than that. But you're pointing out, we don't even have to go that far. We don't even have to skate on that ice. We can simply say there was an exhaustion requirement, which was set forth by the director.
Exactly, and it would not have been futile because, as I said, by the time the board issued its first decision, the Department of Labor or the Secretary of Labor had ratified all the ALJs, and Lucia was almost half a year old.
It did seem to me that the DOL had issued these regs and that the district director had issued regs to the ALJ and the BRB, extensive regulations that said you have to raise and frame issues at one level to have it considered at the next. Yeah. And that's what I thought was the gravamen of the director's instructions and directions to the ALJ and the BRB. Is that correct?
Yes, Your Honor. The issues ideally narrow as the case moves up the appellate chain or up the litigation.
Yeah, what? And what you're trying to do.
Because it's like not actually in the rules, right?
No, because sometimes issues are not resolved and the same ones that were there at the start are still there at the end. Thank you.
Judge Richardson, do you have any further questions?
Not further.
Judge Rushing, do you have any questions?
No, thank you, Judge.
All right, Mr. Austin.
Good morning, Your Honors. May it please the court, I'm Brad Austin. I represent Austin Salmons in this case, the coal miner. I'm coming at this case, I guess, from a bit of a different point of view. I'm one of the attorneys who represent, a volume of coal miners and who've been impacted by cases like this following the Lucia decision. Judge, I think to your point, it was 3,915 days ago that Mr. Salmons filed his federal black lung claim. 3,915 days. Of course, this court knows the procedural history. It's very complicated. From the district director to the ALJ to the BRB, back to the ALJ, back to the BRB, and then to this court. But the issue is this appointments clause challenge did not occur until after the remand. And so, of course, I think this court has a grasp on why that's a potential problem. I believe the court has a very good understanding of that.
Well, I think your comments are well taken because they help to remind us that there is a human being at the end of this line. And this man has gone through layer after layer after layer to try to get those benefits. And the news comes to him and his family, yes, you have those benefits. And then we yank it away from him and say, no, you got to start it all over again. And there's a human being involved here. And I just have a problem with where this is all going in terms of adjudicating cases where people have got people's lungs are no longer pink. They have lost their elasticity. Many of them are choking. It is a miserable thing not to be able to draw a deep breath. And then we're going to introduce further inefficiency and delay into a system which already suffers too much. Do you understand what I'm saying?
Correct, Your Honor, absolutely. And unfortunately, that is something we see every day. And in this case is really evidence of that. Like you said, 3,915 days have passed without finality in this case for this particular coal miner. And Judge, the Glidden versus Zandok Supreme Court case said that these challenges to judges' authority really need to be raised at the earliest possible time. And I do think the time frame is important in this case. You know, Lucia was being decided while this case was at the Benefits Review Board, but 7 months later, the issue was raised for the first time following the remand, which did occur on separate issues from Lucia. It had nothing to do with Lucia. The administrative law judge required, as the regulations require, a pre-hearing statement to address all of those issues. At the formal hearing in this case, the administrative law judge specifically asked the parties, are there any additional new issues that you'd like to raise? Of course, none of that occurred in this case. The employer attempts to argue that this Lucia decision was not in existence. But, you know, Lucia cites the Freytag case from 1991, and that was a special trial judge's inferior officer's case. And the Lucia case specifically said that all of the law in existence was already there to reach the decision in Lucia. So these ALJs are in a much different position than then. So this has been percolating for years. And in the immediate aftermath of Lucia, the Sixth Circuit said in the Joseph Forrester trucking case that there were legions of BLBA cases that were being granted Lucia-related relief. I was part of dozens and dozens of them.
This appointments clause stuff was a hot issue.
Your Honor,
For years in this system. There's no reason they couldn't have raised it.
It was percolating for years, Your Honor, and I do see that my time is almost up, but I completely agree. This, I think the deadlines here, or the time frame here, Lucia was decided in June of 2018. The Benefits Review Board's decision came in November of 2018. And then it wasn't until 7 months after that this was raised. So, Your Honor, I see that I'm out of time, but if the court has any additional questions, I'm happy to take those.
Any questions? All right, Mr. Austin, thank you very much. Mr. Solomon, you have some rebuttal time, sir.
We're missing two aspects of this case. First of all, the constitutional aspect. I think that, you know, I fully understand. I've seen more of these cases, as many of these cases as anybody, and they are sad cases. But that doesn't mean that the problems with these cases is a good reason to deprive employers of the constitutional rights that are preserved to them. I think that the fact that this is the kind of issue that it is, core constitutional issue. First of all, there's no duty on the part of anybody to go through the Supreme Court decisions of the past 30 years and see what might apply to us. I don't think there's any duty to do.
No, that's not. You wouldn't have had to go through Supreme Court decisions for 30 years. This was not only a percolating issue within the Black lung community, it was a hot issue. And as you were on notice that this was an issue, and as a protective matter, any person would have raised that issue in order to preserve it for the next level up. And it didn't require any search of a haystack for a needle to understand that this issue was front and center within the pneumoconiosis community.
Your Honor, we don't have an obligation under the law, under Freitag, under the Social Security decision in Carr versus Saul, to raise an issue before an administrative agency, an executive branch agency that they can't solve. I don't think that we have an obligation to
Counsel,
do it.
I want to ask you about that because I read the board's order to rely on two separate waivers, two separate forfeitures. The board says this issue is forfeited because, number one, you didn't raise it in front of the ALJ the first time. And number two, you didn't raise it in front of the board on your first appeal. And those seem to me to be two separate bases for finding a forfeiture. So even if we accepted that, maybe in front of the ALJ the first time, they couldn't have given you any relief. Maybe you could be excused for that if you had raised it to the board on your first appeal, because there's clearly an exhaustion requirement in front of the board, but you didn't. And I didn't see in your brief this argument that I'm hearing today about, well, even if there's an exhaustion requirement to raise it the first time, you can forgive it because we raised it the second time. I didn't see you arguing that there should be a specific remand regulation, but you can point me in your brief to where that is if you want.
Well, I think in the brief, what we argue is that we didn't forfeit at any time. And when it came back before the administrative law judge, there wasn't any requirement that the case be, that these issues have been raised somewhere before it got back to the administrative law judges. We raised it within the context of the rule that applied to us in that particular situation, which is to say that we raised it as a new issue in writing before the administrative law judge. There's no rule that says you had to have raised it the first time, and really having raised it the first time with the Department of Labor saying you had to raise before the agency, which is completely irrelevant because the agency doesn't even know what it is. And they fill out these forms and send them up to the ALJ. I think that another point I'd like to make, if I may, is that there's a statutory element to this too. And I think the statute controls over the regulations and the Constitution controls over the statute. But the statute does not contain an exhaustion requirement or forfeiture requirement. Let me say something that the Black...
But that's the case, Mr. Solomon, that's the case in a lot of situations where statutes don't cover everything that can be done under a reg. And the question is whether the reg is consistent with the statute. And it is. The statute wanted the Black lung process to move efficiently. And you can't expect every little, that there's no Congress that I know that would have legislated in the kind of detail that you've just set forth.
Your Honor, let me correct you on that. You're wrong here. The Black Lung Act is part of the Mine Safety and Health Act. The Mine Safety and Health Act was written and enacted at the same time, and in the Mine Safety and Health Act, there is a forfeiture requirement written by the same Congress, the same committees. There's an express forfeiture requirement, and it is not carried over into the Black Lung side. Also, Congress, during that same period of time, wrote many statutes with express forfeiture requirements.
Yes, and there are many others that don't. There are many others that don't. It is not a sine qua non for the statute to set up.
Congress.
Do you have some quick, Mr. Solomon? Do you have some quick conclusion you wish to come to?
Oh, yeah. What I'm saying is that Congress did not intend, based upon ordinary principles of construction, to have a forfeiture requirement in that statute, because in the same statute, with respect to another part of it, they did have an express forfeiture requirement. Same writers, same committees, same time that it was enacted.
All right. Thank you, sir. All right, we will appreciate your arguments very much, and we will adjourn court until whenever. I'll let the courtroom deputy decide that.